You're watching the LawNewz Network. Aaron Keller along with you for the afternoon here. And it looks like we've got a break here in closing arguments in the midst of the Luis Toledo case out of Florida. Adam Sostrin is one of our regular afternoon guests here on LawNewz. He's joining us via Skype from California. Adam, good to see you back here on LawNewz.
Aaron, it's always great to be here with you.
Yeah, so we've got a break here, and bottom line is this is one of the longest days of closing arguments I think I can remember. They started first thing this morning. You know, they've taken breaks, they've taken lunch, but they're still at it. And because the burden rests on the state always gets the last word, so we know in this case we're going to be bracing for a rebuttal. So this jury's been going since about 9 o'clock this morning. Here it is 3:19 on the East Coast. This is a long argument in closing.
Right. Well, the defense has a lot of things it's trying to pull to come up with here. You know, it's not a good case for his client. It seems like every which way, with the multiple interviews, multiple statements given by the defendant, the defense doesn't have the best case to work with. So a long talk to the jury about another side is probably the only appropriate thing the defense attorney can do at this point.
I agree. I mean, if I had this case, I would be hard-pressed to figure a theory out, and I think that a few of the points we heard towards the end of that lengthy closing were the best things the defense had to go with. One of them was, we don't know exactly how the children were killed. Well, we don't know how the wife was killed either, but they haven't been seen since October 23rd, and the bank accounts haven't been touched. All their personal effects were left behind. Her car was left behind. Where they have not communicated with family. Where else would they be if not dead? And keep in mind, we've got the blood evidence. So look, I mean, that something happened seems indisputable, even though the defense has tried to dispute it. And do they get anywhere by saying, well, we just don't know how they were killed?
Well, the idea, with that is, of course, trying in some way, however impossible it may seem, to tie it over to the neighbor being responsible for the deaths of the children, to sort of sow doubt in the minds of the jurors. But there are so many cases of circumstantial evidence. It doesn't make sense. Where are these people? Blood was found. Well, it can be enough. I mean, he already admitted to using a karate chop and killing his wife.
Yeah, exactly. So look, I mean, part of me wonders if statements like that are part of a defense attempt to sort of knock this down from the top charge to, one of the lesser included, because here's the bottom line. It's first-degree murder as charged for the kids, but we know from the discussion about the jury instructions, which happened yesterday, and the jury's actually going to get the case tomorrow morning. We know that, okay? Maybe that's why they're taking so much time today. But the jury will be able to consider the lesser included of second-degree murder and aggravated manslaughter for the deaths of the kids. And as to the wife, the charge was second-degree murder, but the judge said he's going to also instruct the jury as to straight-up manslaughter, not aggravated, but just straight-up manslaughter with relation to the death of the wife. So it would seem that really the defense strategy here is to not necessarily try to get an acquittal, although they would love it. I think the chance of that happening is the same that a snowball has, where. But, look, trying to say, hey, look, well, we don't have the bodies. We don't know how they were killed. We can't say for sure that the death of the kids was premeditated. And it's kind of a twisted argument.
What else does he have is the bottom line, and not much. So he has to keep going back to, well, it doesn't make sense that they died in this way, and then how can you possibly say that this was first degree? Especially with the children. Well, you can't even really go there, but you have to create some kind of doubt to make the jurors not hit that mark and to go down. You certainly don't want it to be a death case.
Yeah, that seems to be the defense tactic. Now, why I was saying it was kind of a convoluted or almost a sick argument is because, look, the state is basing the first-degree murder charge on this presumption based on the interrogation of the defendant, one of the several interrogations, that he said that the kids were killed later. He claimed by the neighbor, okay, but he said that the kids were killed later to get rid of them as witnesses, okay, and that's the theory that the state has latched onto. They say, well, he lied about who did it, but he was telling the truth as to why they were killed, okay. Kind of makes no sense within itself, because why would the neighbor kill the kids for witnessing his own confessed murder of the wife? You know, what would the neighbor have? Why would the neighbor care to inject himself in that? But so it's part of this defense argument that it's not premeditated, that's not how it happened. Is the upshot of the argument that the kids were killed first to sort of punish the wife for not admitting the affair, because we've got this piece of evidence that he had asked her to swear on her kids' lives that she was telling the truth about what was going on with this affair. I mean, it's like, no matter how you put it, okay, yeah, maybe it might get you out of the premeditated thing, but it just doesn't look good no matter where you go.
Right. Well, I mean, well, first off, it does in a way sort of tend to the premeditation if you're swearing on the lives of the children, but it doesn't cut well either way for the defense. I wouldn't be surprised if the prosecution gets everything they want in this case.
I wouldn't be surprised either. I mean, if I were sitting on the jury, I would see through what the defense is throwing up right now. And look, I mean, I've been watching this trial, almost all of it. Not every second of it, but most of it. And, look, it seems like it's being tried well. The judge seems fair. The prosecutor seems ethical in his arguments. The rules of evidence are being followed. The defense seems like it's doing as good a job as possible with the bad facts that it has. So I'm just looking at it saying, hey, look, sometimes I sit here and I really am concerned about the way the case is being tried. I don't have those concerns with this one, at least based on what I've seen. So we're just here saying, hey, look, it's a horrible situation.
This is a case for the prosecution to lose and the defense to win. The prosecution's not supposed to do any tricks or anything like that. They have everything they need. This is pretty well, laid out. They don't have to resort to anything sort of dirty. They don't have to. Just move forward, say, what the state of the evidence is. Such an easy case. I think, of course, if I were the prosecutor, I've never been one, but it seems with all those interviews given by the defendant that this is almost formulaic.
It seems that way. I mean, the only thing I'm sure the prosecutor wishes that he had was some body, to indicate exactly how each of the individuals had been killed.
It would be nice to know.
Maybe some sense. Yeah, I mean, that it would be nice to know, but I think that the prosecutor did a great job on closing argument of saying, hey, look, we do have enough here. And we not only have enough to implicate the defendant, but we have enough to poke holes in the defense's theory that it was the neighbor involved. Look, it's the defendant's shoe print on some of the items that were thrown in the dumpster at the apartment complex near where the wife's car was ditched, okay?
There's no question. The case is so good. And I think we even have a statement from that officer that overheard the defendant say, you're never going to find the bodies. I mean, when do you have that?
Yeah, I mean, and of course, the defense was sitting there saying just a few moments ago, hey, look, well, why wasn't that on the recording, blah, 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 this. Well, gee, because the defendant knew he was being recorded, that's why he didn't say it in the interrogation room, I'm sure.
No question. It's a spontaneous utterance. It is an admission. This is something that absolutely comes in, kills, no pun intended, the defendant's case, and this is a tragedy. But I don't see any way out of it right now for the defense.
Yeah, and as I was saying, I think that the state did a great job of pointing out why this theory that the neighbor was involved just doesn't make any sense, because there isn't evidence in the dumpsters, in the car, anywhere else tying the neighbor to the scene, and the defendant changed his own story a couple of different times trying to implicate the neighbor after his initial story implicated nobody else. So, we've got that. First the defendant says, I was asleep in my car in the parking lot. Then he claims that the neighbor was over and, playing video games, and this whole thing went down, and makes this statement, well, you'll find his fingerprints on the video games. They didn't even find that. So is
Yeah,
the defendant reaching for something like, weeks or months before the neighbor had been playing video games at his place and hoping the prints are still there? Well, guess what? They weren't.
this sort of reminds me of something that an old when I first started off at the public defender's office, an old public defender told me, it's your job, it's the defendant's job to lie to you, and it's your job to represent the defendant. You can't proffer evidence if you absolutely know it's false. I can only imagine that the defendant is telling his attorney, not that we're ever supposed to be know about those discussions, but that this happened, that this neighbor, he was the person that killed the kids. I can only assume the defendant is probably telling his attorneys just that.
One has to wonder. Sometimes I wonder what conversations go on between defense attorneys and their clients. I try not to guess because we will never know, at least if the rules of professional conduct are being followed. So,
Yes.
If we were to take a guess, do you think this is going to be a short deliberation once the jury gets the case tomorrow, or a long one?
I think it's probably going to be a short deliberation. I really do. I can understand that the premeditation component, it's difficult to do. It seems like this is something that's just so that, a switch was flipped on and the defendant sort of went crazy, during those early morning hours. But there's going to be convictions that are going to occur pretty soon after the deliberation, I imagine.
So one of the interesting lines used by the prosecution this morning in the initial closing argument, not the rebuttal, which is coming up,
Sure.
was ultimately that, hey, look, there are two age-old motives for crime if you go back through human history. Two motives for murder, and this defendant had both of them. One is to eliminate witnesses, and the other is because a lover is caught cheating. I thought that was a pretty effective line.
It's so effective. There's only so many, and I've heard this from investigators before. People kill people for sex, and they kill people for money. This we know exactly what happened. We know all about the fact that there was this affair, that there was this confronting of the victim regarding the affair. Everybody knows about it. Everybody knows that she appeared to have an injury. And the defendant just finding out about it, it just, of course, it gels into something easy for the prosecutor to prove. Sex and money. You have sex here.
Do you think that there's a chance the jury might knock the charges down because the jury might look and say, hey, look, this guy suspected an affair. The victim, unfortunately, just was back and forth about whether she was or wasn't involved, and then says, well, when I admitted it, I was lying, just trying to get you off my back. And she's sort of swirling things around. Do you think a jury might look at this and say, hey, look, this guy was completely off his rockers, but we can understand why?
Absolutely possible. He went completely nuts. And this is what occurred. I could see jurors coming back not as the first degree, but as the second degree. Sure.
I could possibly see that with relation to but the wife's murder isn't facing a first degree murder charge. That's a second degree. Do you think they can knock it all the way down to manslaughter?
I think it's possible. I do.
So that might be an interesting one. And look, I'm not saying that in any way I condone this thought process, because as far as I'm concerned, if that set this guy off that much, I still think the second degree murder charge could stick.
Right. No, of course. But it is the the textbook definition of what is voluntary manslaughter. It is sort of a heat of passion offense that occurs, and then the example that we're given also in law school is somebody finds out somebody's been cheating.
Yeah, and usually they catch them right straight in the act, though, for a heat of passion crime, not catch them and then argue with them over text messages for more than a day, show up at their workplace, show up at their mother's house, and then get into more of a confrontation with them back at home. That's more than just an immediate heat of passion.
Sure. I mean, there was clearly some back and forth about it, but it doesn't mean that the defendant couldn't have at some point just reacted violently to the situation without premeditating the murder.
Yeah, we're wondering if there's going to be some more activity in court soon, because we got the feed for just a second, and then on the transmission end it was cut off. So they may be coming back in here soon. In theory, I guess the prosecution has, in theory, a good hour and a half to try to rebut what was said by the defense here. Do you think that the state really needs to belabor the points, or does this need to be a short, staccato rebuttal, in your opinion, Adam?
Quick and easy. Short and sweet, to the point. The prosecutor knows what he's supposed to show for these offenses. Of course, he wants the stronger charge to stick with the children. The children obviously weren't cheating on the husband. Obviously the idea of getting rid of evidence is a pretty good motive. He wants the first degree to stick.
Yeah, and part of me wonders if some of the critical evidence here is going to be the disposal of the knife. I mean, the state was very honest in closing and saying, hey, look, he had this scary looking knife. He threw it out the window. We can't connect the knife to the crime, but the act of disposing it, when the police are starting to look around, might be evidence of consciousness of guilt. And then we've got the suicide attempt back at the police station. Is that evidence of consciousness of guilt, as the state has alleged?
Absolutely. No question. If I were the prosecutor, I would want to point that out. It is a type of, consciousness of guilt to do something like that. Of course, if I were the defense attorney, I would object to evidence coming in for that purpose. It doesn't show necessarily, let's say, not necessarily that he's responsible for the deaths of the children. I guess I would have to sort of raise those points, but it's so easy for a judge just to allow evidence for that purpose with respect to how the defendant acted. Who else is going to do something like that except for somebody who's responsible for the crime? The suicide attempt, though, I don't think that that's necessarily consciousness of guilt.
Not per se, and is it just because it was too removed from a time standpoint, or what's your basis for that?
Well, I mean, just that how would anyone feel, of course, if somebody had murdered their children? They might feel so despondent that this is something that they could do. So, but of course, with respect to the death of his wife, then that's what I would argue if I'm the prosecutor, to get that in for, oh, this is evidence of, the clear guilt, the guilty conscience of the defendant.
We talked a little bit just a few moments ago about this whole nature of this being either a crime of passion or a heat of passion crime, and whether it was more deliberated, premeditated. Do you think that the statement to the neighbor, the quote, "I snapped," which was allegedly uttered by the defendant on the way back home from ditching the car in the neighboring county, do you think that maybe at least one juror is going to get into that and say, hey, look, when you look at the text messages and then you couple it with that statement, "I snapped," that he literally is saying, "I snapped," and therefore not reach this whole nature of premeditation against either of the two kids?
Well, it's a perfect case for heat of passion, no question. I guess, the prosecutor could come up with an argument that it's sort of self-serving. He doesn't want anyone to think that, that anything he had done was deliberate or premeditated.
We've got the daughter's blood in the house, in the master bedroom, on the defendant's left shoe, in the wife's trunk mat. That seems to me the best evidence for the prosecution that, well, he admitted to killing the wife. That blood is evidence that the daughter is dead. Is it okay for the jury to reach the connection that the son also was killed too by inference?
Absolutely. That's certainly something. I mean, where are those children today? We have blood with respect to one of the children on the defendant's clothing. I would absolutely, if I were a juror, make that leap.
Yeah, and that's turning into a legal argument here. The defense saying, hey, look, the state's got to prove that one beyond a reasonable doubt too. Part of me wonders, okay, well, in theory, could this be a split where there's a conviction for the daughter's murder based on the blood, but not on the son's murder?
I think probably with it's potentially possible, but the fact of the matter is that one of those children is clearly missing. There's no good evidence with respect to the neighbor's involvement. We know the defendant was cleaning his vehicle. All these things that sort of show a destruction of evidence over time. So I still think that there's probably going to be a conviction with respect to the son and the daughter, both.
I would tend to agree, but we have activity in the courtroom. It looks like they're coming back. The judge just asked how much time this is going to continue to take. It's been a long day of closing argument thus far, and they will continue. So Adam Sostrin from California, thanks for joining us this afternoon here on Law News.
Thanks for having me.